Well, hello, everyone, and thank you for joining today's webinar on Queensland's Child Safe Organisations Act and Child Safe Standards. My name's Kate Scanlon, and I'm one of the Capacity Building Coordinators at Community Legal Centres Queensland. I'd like to start by acknowledging the traditional owners of the land that we're running today's webinar here in Meanjin in Brisbane. They're the Turrbal and Yagara people. I'd like to acknowledge that these are stolen lands and that sovereignty was never ceded, and pay my respects to any elders past and present. I'd also like to acknowledge that this webinar is being viewed by people not just in Queensland, but around Australia, and acknowledge the lands that you might be joining us on today, as well as any First Nations people viewing this webinar. So today, we're very pleased to welcome Anne Edwards, who is the Executive Director of Child Safe Organisations. And I'll let Anne tell you a little bit more about herself in a moment. But before I do that, just some housekeeping. Today's webinar is being recorded. You'll get a copy of the recording at the end. We'll probably send that out probably tomorrow, and it'll be available on our website as well. We encourage you to ask questions. If you have any questions, there is an option to ask it down the bottom of your control panel, and they'll be answered generally at the end of the webinar, but some may be answered throughout as well. But now I'll hand over to Anne. Thank you.
Great. Thank you very much. Well, thank you so much for having us today. We're really pleased to be here to chat to you about child safe organisations. I wanted to start quickly with a fun kind of activity and wondered if you could all scan the QR code there, grab out your phone. And I don't know if many of you are familiar with the Slido package thing that comes on the magical software, but this is a way of getting you all interested, engaged. So if you could scan that QR code, and it should take you to a screen that says, or a question that says, what words come to mind when you hear child safe organisations? So if you just tap in your response to that. Oh, blue card, fantastic. What I'll do is I am going to share the screen that shows you the results of that as we go, if I can find it. There it is. A lot of people saying blue card definitely pops out to them as a child safe organisations matter. Duty of care, fantastic. New legislation, love to see that one there. Lots of blue cards, child safety protection, safety, diversity, schools. That's fantastic. You've obviously had a chance to have a quick squiz at the legislation and the new requirements, because you've picked out a few things there that are really relevant to child safe organisations. Fantastic. So I'm speaking to an audience that obviously knows a little bit more about this than perhaps the average audience. So thank you. Amazing. Wow. Keep it coming. Safety, child protection, safe space, child abuse, safeguard. Oh, Anne Hollins. She's fantastic. She was a former Commonwealth, Children's Commissioner. Prevention, due diligence. Fantastic. Thank you so much. We're going to return back to the screen. Hopefully you can see my presentation screen there. And I'll introduce myself. I'm the Executive Director of the Child Safe Organisations team, which is part of the Queensland Family and Child Commission. It's a fairly new business team, obviously, given that the legislation is brand new. So throughout this presentation, I'll be walking you through the Queensland's new Child Safe Organisations Act 2024, which commenced last Wednesday, the 1st of October. So we are now in full-on commencement mode. And I'll talk a little bit more about that as we get into the presentation. So we'll explore what the Act means in practice, including child safe standards, the universal principle, and the reportable conduct scheme, which all together form the Child Safe Organisations Act. And the goal of today is to give you a clear understanding of the reforms, how they work together, and how they support safer environments for children and young people across Queensland. So I want to also acknowledge country and recognise the Yagara and Turrbal peoples on which we're meeting today. Well, I'm on those lands today in Meanjin. I want to recognise the crucial role that First Nations communities, organisations and individuals play in safeguarding our children. Without cultural safety, First Nations children are not safe. And we all know that culturally safe environment is simply a safer and more empowering environment for all children. So another Slido poll, just to get you into the swing of it. Can I ask you two questions? Firstly, let's start with how confident are you to explain the child safe standards to a colleague? So if you were talking to someone in your organisation, how confident would you be in the advice that you're providing to them about what this is? And so it's asking for a scale of 1 to 10, so 1 being not at all confident and 10 being very confident. And I'm just going to share with you the Slido outcomes as they come through. So lots of people on the lower end of the confidence spectrum, I guess, and some in the middle. Nobody at 10 yet, but I'm sure there's someone out there who has done a fine-tooth comb on the legislation and has a really good understanding. A couple of people there at 9, which is really great. And the 7s, 8s, and 9s are, well, the 8s and 9s are pretty low, about middling. Okay, so roughly about half and half think that they, or in that middle section, feeling sort of not overly confident, but also not completely unconfident. So that's good. The next question we are going to ask is, how confident are you with applying cultural safety to the child safe standards? So let me go back to the, oh gosh, this is a bit tricky. I shall go back to the screen. Here we go. So the next question being, how confident are you with applying cultural safety in the child safe standards? So 1 again being not at all confident and 10 being very confident. How would you feel about that one? And I'll go back to show you the responses here. So again, looking around middle confidence, perhaps leaning to the left there on not altogether confident. And this is where we're hoping we can give you some information that helps you feel far more confident about how to apply cultural safety. So clearly there, people feeling a little bit less confident about that. And I can understand why, given it's a fairly unclear sort of concept to think about. All right, we're going to come back to this at the end to see how people have changed their views and feelings as we go through the presentation. Thank you so much for participating in that, by the way. Okay, so before we dive into the details of the legislation, I wanted to take a minute to talk about the background, so the journey that's brought us here. Queensland's Child Safe Organisations Act is a direct response to the recommendations of the Royal Commission into Institutional Responses to Child Sexual Abuse, and that Royal Commission uncovered true systemic failures that allowed abuse to happen, to be hidden, and to go unaddressed for far too long. But the Royal Commission also gave us a roadmap for change, so a way forward. And that included establishing clear, enforceable standards to help organisations create environments where children are genuinely safe, respected, and empowered. So the reform isn't just about compliance, it's actually about cultural change within organisations. It's about making sure that every organisation working with children in Queensland understands the responsibilities and is supported to meet them. So they're just showing you that coming out of that Royal Commission, almost all states and territories now have fully or partially implemented a CSO scheme, a Child Safe Organisations scheme. And in Queensland, we are slightly different in that we've adopted also this universal principle of cultural safety, as we call it, for First Nations children and young people in particular. And this universal principle of cultural safety needs to be embedded in each of the 10 standards under the Child Safe Organisations Act. So all of those child safe standards need to think about and turn their minds to how they can be implemented in a culturally safe way. So the child safe standards and the reportable conduct scheme are complementary parts of one integrated child safe system. So together they support organisations to be proactive, preventative and responsive, to identify risks early and take meaningful action to address them. In Queensland, the universal principle of cultural safety will apply across all those standards, as I said, acting as a guiding principle that influences how every part of the scheme is delivered. Why do we need it? Well, I guess I'm not sure I need to tell you folk how prevalent we know that child sexual abuse is in our world. So the Australian Child Maltreatment Study there, which was a survey of a random sample of 8,500 Australians aged 16 to 65, found that 28.5% reported having experienced child sexual abuse. Now, obviously, not all of that was occurring in institutions themselves. We know that most child sexual abuse is occurring in a family context or friends of family, but we do know that a component of that child sexual abuse occurs in institutions. And of those who had experienced it, 78% reported that the abuse occurred more than once. So it's not a one-off event, it can be repeated over time. The ABS Personal Safety Survey estimates that at least 195,200 Australians were sexually abused before the age of 15 in an institutional setting. So that is still a huge number of children being sexually abused in institutions before the age of 15. So these are real people. This is real impact. And as we know, child sexual abuse is not, it has lifelong impacts as well. And again, the National Redress Scheme has seen nearly 50,000 applications to compensate them as survivors of institutional child sexual abuse. If we look at more current data, we can see the ongoing nature of this issue. So in 2023-24, the Office of the Children's Guardian in New South Wales received 2,405 notifications to the reportable conduct scheme, which was an increase of 19% from the year before. In Victoria, it was 3,831 allegations reported to their Commission for Children and Young People. Now, we don't have comparable data for Queensland just yet, but it's highly likely that we are going to be seeing similar levels of risk and harm here being reported under the reportable conduct scheme. So when we talk about child-safe organisations, we are talking about preventing not only harm, but that long-term trauma that is associated with child sexual abuse. And it's really about protecting our future. One thing we can say is that this is already a saturated market. So we understand we are entering a place of public scrutiny where there is already a lot of players in place. So there are many checks and balances already in the system, all designed with the intention of keeping children safe. We have mandatory reporting, we have police investigations, we have complaint mechanisms, risk assessments, quality standards, and regulatory frameworks for different parts of the system that looking after different types of cohorts of children. But each of these systems, each cog in that machine has its own rules. So they each have their own threshold for when harm should be reported or investigated. They each are governed by their own privacy laws with different limitations on what information can be shared. Each faces bottlenecks, inefficiencies, and sometimes outright failures. And each has its own set of challenges when it comes to reporting abuse, including reluctance, fear, and barriers that stop people from speaking up. And each is shaped by its own culture, which can either support or suppress efforts to keep children safe. So while the individual parts may be working hard, they're not always working together. And there are a lot of cogs in that machine, but right now they're not all turning in unison. And that's what the Child Safe Organisations Act aims to change by providing a framework that brings these systems into better alignment, improving coordination, and ensuring we don't let children fall through the gaps. As I was trying to explain earlier, the Act provides two halves of one system. So it's It's a critical reform, but it's not the complete solution. We need to acknowledge that up front. So no single piece of legislation can fix every issue in the system, but the Act gives us these two powerful tools that will make things better. They bring new checks and balances into place for all child-serving organisations. The standards are about prevention, and the universal principle sits within all of those standards. About building cultures and capability that prevent harm from happening in the first place. And then the reportable conduct scheme is about the response. What happens when harm does occur and how we deal with it in a way that's accountable, transparent, and puts children at the centre. So together they overlap because to work effectively, prevention and response need to be connected in that way. They need to inform and strengthen each other. And when they do, they have the potential to transform the child safeguarding culture of our state in Queensland. Okay, so let's turn to the legislation itself. The Act establishes an integrated child safeguarding system. Enforcement powers are there, but consistent with the Royal Commission's intent, they're used only after education, support, and capacity building has been provided. In the next few minutes, I'll step through what the Act does in practice, who's in scope, when requirements commence, and how the phased rollout works, what organisations must do to meet the standards, what the reportable conduct scheme requires, and how the Queensland Family and Child Commission will regulate, starting with guidance and support and moving to compliance action only when needed. I'll also point to the practical resources and sector supports available to help you translate this into day-to-day practice. Okay, so at its core, the purpose of the Act is pretty straightforward but vital, and vital that we keep this at the heart of everything we do, to protect children from harm, but not only that, to promote the safety, well-being and best interests of children. So it's beyond child safety and protection and far more a broader culture of safeguarding, which is a broader term meaning that the well-being of children, the cultural safety of children is integral to the sense of protecting children from harm. So to achieve it, the Act brings in three major reforms. It establishes that all Queensland child-safe entities must comply with the 10 child-safe standards. These are based on the National Principles for Child-Safe Organisations and are now mandatory under Queensland law. Importantly, Queensland, as I was saying, includes the universal principle of cultural safety, which applies across the 10. Secondly, the Act establishes a reportable conduct scheme, which creates a clear and accountable process for how organisations within scope must respond to and report on allegations of child abuse involving their staff or volunteers. And thirdly, the Act formally establishes the Commission, us, the Queensland Family and Child Commission, as the independent oversight body for the scheme, which means we're responsible for administering the Act, supporting compliance, monitoring performance, and taking enforcement action if needed. So the Act uses a few important terms that I want to call out. Firstly, that concept of child-safe entities. So these are organisations that either provide services specifically for children or that operate facilities specifically for children who are under their supervision. The Act also talks about reporting entities, and these are the subject of a subset of child-safe entities that have additional obligations under the reportable conduct scheme, things like investigation and notification requirements. And I'll come back to those in a bit when we start to talk about those. So what is a child-safe entity? The Act defines a child-safe entity as one that either provides services specifically for children or operates facilities specifically for children under the supervision of the entity and is either listed in Schedule 1 of the Act or is prescribed by regulation. So when we talk about an entity, that term can be quite broad. So it can apply to an incorporated organisation, an unincorporated body or association, a sole trader, or a partnership. So a child-safe entity is any and all of those ways of delivering a service. However, an individual person is not considered a child-safe entity unless they're carrying on a business. So, for example, a sole trader or a partner in a partnership. So the question often comes up, how can I be sure my organisation is in scope? And that's a very fair question. And sometimes organisations may want to seek their own legal advice about that. The best place to start is by checking whether you fall within the categories listed in Schedule 1 of the Act, or whether you're captured by any regulation made under the Act. And we'll be providing further guidance and tools to help organisations work through this issue, particularly as we move closer to implementation. In any event, given that we're talking to community legal centres, we know that Schedule 1, Section 8, pertains to justice and detention services sector, and I'll just read from the schedule the definition of a child safe entity under that section, which is an entity that provides programs and services mentioned in the Youth Justice Act 1992, Section 302. Secondly, an entity that provides legal or other advocacy services, including, for example, a community legal centre or a provider of court support services. So you actually get an explicit mention here in the Act. And thirdly, an entity that provides diversionary, interventionist or rehabilitation activities, including, for example, a graffiti removal program under the Police Powers and Responsibilities Act, Section 379A, or bail support services. So definitely in scope then as a child safe entity. Again, a follow-up question is, what exactly are services specifically for children? Now, the term doesn't necessarily mean that services must be exclusively for children. Rather, it refers to services that are particularly aimed at children or have a special application for children in the way that they're delivered. So even if a service is provided to both adults and children, it can still fall within scope because part of the service was designed or intended to meet the needs of children. There are also some cases where at first glance, a service might appear to be primarily for parents or carers, but because the service is designed to support the safety and well-being of children, it's still considered a service for children under the Act. That's an important nuance, and it reminds us that services don't need to be delivered to children directly. They can be delivered for children and still come under the scope of the legislation. Okay. So scope, one of the key questions we also get is, how do we apply the standards or implement the requirements in a way that makes sense across a large or complex organisation? And the answer lies in recognising that not every part of an organisation will interact with children in the same way or to the same extent. So when it comes to things like policies, procedures, or training, these don't need to look exactly the same across the board. Instead, the approach should be proportionate. So, for example, staff who work directly with children every day might need more in-depth training or more detailed procedures than someone working in a back office type function. So this flexibility is built into the Act and it's there for a reason. So it ensures that implementation is both meaningful and practical, tailored to the nature of the work while still delivering on the core intent of keeping children safe. So who is considered a worker? And the term, again, not surprisingly, is defined quite broadly under the Act. This is deliberate again because we know that organisations look very different across sectors. So some are large with many departments, some are small or volunteer run, and many sit somewhere in between. So rather than restricting the definition to just paid employees, the Act captures a wide range of people who are employed or otherwise engaged by an organisation. That might include contractors, volunteers, consultants, really anyone performing work on behalf of the entity. So this broad definition ensures that obligations under the Act apply consistently regardless of the structure or size of the organisation. Now we've looked at the legislation itself, let's step back and consider the broader system that Child Safe Organisations is helping to shape. So when we say child safe organisation system, we're talking about more than just compliance or tick box obligations. We're talking about a system that's preventative, proactive, and grounded in shared responsibility across government, across sectors, and across communities. This system includes the standards and the reportable conduct scheme, but it also involves education, cultural change, collaboration between regulators, and accountability. It's designed to ensure that child safeguarding becomes business as usual, part of how organisations operate every day, not just when something goes wrong. What does it mean to be a child safe organisation? At its core, a child safe organisation is a place that consciously and systematically puts children's safety and well-being at the very centre of everything it does. It's an environment where children's rights and human rights aren't just acknowledged, but are deeply understood and upheld by everyone involved, whether they're staff, volunteers, or leaders. These rights are embedded in the organisation's policies, its day-to-day practices, and its overall approach to working with children. Being child safe means genuinely engaging with children, listening to their ideas and opinions, and valuing what they have to say. And importantly, it means using their input to help shape decisions. Their voices aren't just heard, they're actually acted on. It also means taking deliberate steps to reduce the likelihood of harm occurring in the first place. At the same time, increasing the chances that if harm does occur or is suspected, it will be identified early. A child safe organisation recognises and responds to any concerns, disclosures, allegations, or suspicions of harm quickly, appropriately, and with the child's best interests at heart. And it also helps people to identify when a child is saying something of importance. It's not always easy to identify when a child's making a disclosure or when they're raising a concern or a worry. So hopefully the kinds of systems you have in place for staff and volunteers helps them identify when a child's expressing some level of concern about the service that they're receiving. So these aren't just surface level commitments, they're embedded in the culture of the organisation. From the leadership team right through to volunteers, everyone embodies child safety in their behaviour, their decisions, and their attitudes. And finally, a child safe organisation understands that this work is actually never finished. It engages in a continuous process of reflection and improvement, constantly analysing its performance, identifying opportunities to do better, making changes to ensure that children's safety and well-being is always prioritised. Because ultimately, being a child-safe organisation isn't just about ticking boxes. It's about building a culture where children are truly safe and valued every single day. The Royal Commission made it clear that proportional responses to compliance should be a core principle of any regulatory approach. That intent has been definitely built into the Queensland legislation, and we are adopting it very closely. As the oversight body, we're committed to upholding the principle of proportionate response. So it's not only legislated, it's also consistent with how the scheme is being implemented across other jurisdictions, and we've learned a lot from our interstate colleagues. This framework illustrates how our regulatory approach always starts with informing, educating, and supporting organisations. That's where the majority of our effort and our regulatory activity will be focused. Of course, we will enforce the law where necessary, but enforcement is always a last resort, something we turn to only after reasonable efforts to build capability and support have been exhausted. Throughout this process, we're also actively assessing and profiling the level of risk to children. So when we identify concerns, we don't act alone. We're proactively sharing intelligence with other key agencies, including the Queensland Police Service and Blue Card services, as well as other relevant regulatory bodies. We've just published a statement on our website that talks through this regulatory theory that we have and will guide our work as a regulator, which you can go and have a look at. So let's turn to the heart of the legislation, the child safe standards and the universal principle. These aren't going to be new ideas for most of you. They're based on the national principles for child safe organisations, which many in your sector are already familiar with. But what the Act does give is these 10 standards legal weight. That means that all in-scope child safe entities must implement the standards and the universal principle of cultural safety. This principle recognises that cultural safety, I've already said that. In a moment, I'll walk you through what it looks like in practice, but I want to emphasise that these standards are not a checklist. They're a framework for cultural and behavioural change, and they ask organisations to reflect, to improve, and to prioritise children's safety and voices. Here they are, the 10 child safe standards. So you can jump on our website, you can download these. We will no doubt leave you with a copy of the presentation slides so that you can wander through these at your leisure. But they start with leadership, governance, and culture. And culture being that operative word that I've used a fair bit of, but it's about how you create your organisation to centre children's rights and children's voice and prioritise their well-being. Children are informed about their rights, so they actually have information at hand that tells them how they can make a complaint, how they can raise issues. Families and communities are informed as well and involved in promoting child safety and well-being. So often we see our parents, families and communities as being critical partners in helping ensure that organisations are aware of their obligations under the Act. So we'll be communicating with them separately to make sure they're raising those questions with organisations. Equity and diversity are critical and they are respected in policy and practice. People working with children are suitable, and that's where our blue card point comes in. So blue card is part of that, but it's not everything. Processes to respond to complaints and concerns are child-focused. So lots of us have complaint mechanisms in place, but how easy are they for a young person or a child to access? Staff and volunteers of the entity are equipped with the knowledge, skills and awareness to keep children safe through ongoing education and training. Physical and online environments promote safety and well-being. Number 9 is my personal favourite, so that's about that continuous improvement, making sure that implementation is something that is regularly revisited and improved. And finally, and I guess the reason why it's last, is policies and procedures document how the entity is safe for children. We want policies and procedures to reflect practice. We don't want the opposite. So we want to make sure that the bits of paper that show us and tell us that your child's safe are actually just reflecting your practice already. So that's why I guess that one comes last, but it's nevertheless an important one. So the legislation's introduced this phased implementation approach, meaning that different sectors will be expected to comply with the requirements at different points in time. There are 2 main reasons, and firstly, it gives sectors that don't currently have strong child safeguarding frameworks a bit extra time to build their systems and practices. And secondly, it allows us at the Commission to phase our work. So first establishing the child safe standards system and then moving to the reportable conduct scheme. So again, speaking to you all here, you are already commenced. So from last week, the Justice or Detention Services, which includes community legal services, should be working to be compliant with the 10 child safe standards. Every organisation in Queensland is starting from a different place. We acknowledge that, and it's absolutely okay. So every organisation will have its own unique journey toward becoming a child safe organisation, and that means the approach needs to be tailored. For many, the transition won't require a complete overhaul. Organisations that already place children's safety, wellbeing and best interests at the heart of their work are likely to already be meeting a number of the obligations under the new system. In fact, a lot of organisations already have strong foundations in place. If you've adopted and embedded the Blue Card child and youth risk management strategy, for example, you're already a long way down the path to meeting the child safe standards. So this is an important starting point, recognising and building on what already exists and using that as a springboard for further improvement and alignment with the new legislative requirements. We spoke briefly about cultural safety. So as we begin developing clearer definitions and guidance, there are already some fundamental truths we're working from when it comes to cultural safety. So first and foremost, Aboriginal and Torres Strait Islander people must define and measure cultural safety for themselves. This principle is non-negotiable. And we also know that achieving cultural safety requires individuals at every level of an organisation to develop the knowledge, skills and attitudes needed to recognise and actively address bias, racism and harmful stereotypes. And finally, we know that cultural safety isn't just about changing people, it's about transforming systems. The goal is to reshape organisations and services so that they genuinely work better for Aboriginal and Torres Strait Islander children, families and communities. So Clearly, a journey of learning, listening, and continuous improvement, and we're committed to doing that together. As we deepen our understanding of what it means to embed the universal principle in practice, we need to be clear that it isn't just about adding cultural safety onto existing systems. It's about that transformation that we're looking at. Firstly, the transformation begins with unlearning. So it means actively challenging and dismantling unconscious bias, racism, and discrimination within an organisation. Secondly, it means negotiating values, motivations, and paradigms. This is why leveraging opportunities for co-design is important. Policies, programs, and practices must be shaped in partnership with Aboriginal and Torres Strait Islander communities so that their perspectives on children's safety are reflected and respected. Thirdly, we need to prioritise social and emotional wellbeing, not just for children, but also for families, communities, and the staff working within the system. That means taking a holistic, strengths-based approach. Power must be shared, and that's one of the principles of the Closing the Gap framework, which is that decision-making processes should include Aboriginal and Torres Strait Islander people, creating space for genuine partnership. Resources must also be shared, which means committing actual funding, staffing, and infrastructure to First Nations-led initiatives, research, and governance mechanisms. We also need to create a strategic enabling environment. Leadership has to set clear priorities and establish accountability structures to ensure cultural safety isn't a project, it's part of daily operations. Importantly, we must be willing to operate on Aboriginal and Torres Strait Islander terms of reference. This includes grounding service delivery in First Nations knowledge systems and self-determination principles. And finally, we must embed accountability and continuous improvement. Again, that continuous improvement theme shines through. So progress must be measured using indicators defined by Aboriginal and Torres Strait Islander peoples themselves, because only they can we be sure that we're achieving the kind of meaningful change that this work demands of us. I'm going to start skipping through a few of these. These are some of the findings of the Royal Commission into Institutional Child Sexual Abuse. What does it look like in practice? So it's important to emphasise that there's no one-size-fits-all approach to cultural safety. No surprises there. Each Aboriginal and Torres Strait Islander community throughout Queensland is different and has different perspectives on and experiences about cultural safety in practice. So we'll be providing guidance, more guidance about this, and there'll be specific activities we recommend, but each organisation will need to adopt and adapt these in ways that make sense for them and their unique context, their unique community, and their unique service environment. What matters most is that cultural safety is not treated as a checklist, as the Child Safe Standards. It's something that must be lived and felt across all parts of the organisation. Because ultimately, if an organisation is not culturally safe, it's not child safe. All right, I'm going to talk about the reportable conduct scheme. Let's shift gears. In the previous sections of this presentation, we've spent time talking about the proactive preventative elements of the child safe organisation system, those things we can put in place to stop harm before it occurs. But safeguarding doesn't end there. We also need robust, accountable processes and responses when concerns do arise. This reportable conduct scheme is a crucial mechanism for ensuring that allegations of harm, particularly involving workers or volunteers, are taken seriously, they're investigated appropriately, and responded to in a way that prioritises children's safety and rights. Let's unpack what that means. So, reportable conduct, clarity here is really important. The term reportable conduct refers to specific types of behaviour involving a worker that may pose a risk to children's safety or well-being. So the examples listed on the screen form a foundation of what must be reported under the scheme. And there are two components of this. There are reportable allegations and also reportable convictions. So an allegation is something that has been raised as something that has occurred in the organisation. A conviction is where a worker has been found guilty of an offence already under state or Commonwealth law that may involve reportable conduct. So it's conviction for any of those behaviours on the left side of the screen. As you can imagine, this brings with it important judgment calls. Part of our role as the regulator will be helping organisations navigate this space, particularly in determining when a concern reaches a threshold that requires a report to us under the scheme or meets the criminal threshold requiring referral to police. This brings us to some of the real-world challenges that we're anticipating as we move closer to the commencement of the reportable conduct scheme. First, I want to touch on the idea of integration. One of the key benefits of this scheme is that risks identified through individual investigations won't sit in isolation. They may reveal patterns or broader issues within an organisation's culture or systems. That means we have an opportunity not just to respond to individual incidents, but to use that information to drive change across the organisation and potentially across the entire child safe system. Alongside those opportunities, we're also preparing for a number of challenges. So we are expecting a high volume of reportable conduct notifications coming into the Commission, particularly in the early days of implementation. At the same time, we're aware that some child safe organisations may not have strong internal capability when it comes to conducting investigations themselves. So that's going to be a critical area for support and capacity building by us and others. We also anticipate some tension in how investigations are shared across the regulatory landscape. In some cases, other regulators may be required to take the lead on an investigation. In others, there might be too many investigations running in parallel. Either way, it's a coordination issue and something we're going to need clear protocols and relationships in place to manage. There's also the risk that some organisations may hesitate to make reports under the scheme, and that hesitation could stem from uncertainty about thresholds, fear of reputational damage, or simply a lack of understanding about what constitutes reportable conduct. Our role is going to be to provide guidance and reassurance so that organisations feel supported to do the right thing. And finally, we know that when harm does occur, the response often involves multiple agencies, whether that's child safety, the Queensland Police Service, or other regulators. Bringing those agencies together in a coordinated and timely way will be essential to protecting children, but will also be complex and sometimes challenging. So again, under the reporting entities, justice or detention services are listed for the 1st of July 2026, but happily under the Act, the schedule does not include community legal centres. So you'll be relieved to know that you will not be, as a community legal centre, necessarily a reporting entity for the purposes of the Act. Your responsibilities will principally lie with the child safe standards and implementing those. So again, the phased implementation approach, and given the the ongoing anxiety about early education, early childhood education and care services, they've been brought forward to the 1st of July 2026. And then from there, they'll be fully implemented by the 1st of July 2027. So obviously there's a lot of existing sector oversight in the justice and detention space. So the Bar Association Queensland helps set a professional ethical standard that has the values of child safe standards, shaping legal practice so that dealing with children is done carefully and respectfully. So we're aware of that. The implementation of the child safe standards and the reportable conduct scheme should build on this foundation with an emphasis on collaboration, shared stewardship, and aligning existing frameworks to embed child safety more deeply across the sector. So we're not seeking to duplicate oversight. We're absolutely trying to be collaborative in our regulatory efforts. So that means working together with existing sector regulators and enablers to understand what's already in place and how it aligns with the child safe standards and reportable conduct scheme. Right, now some fun again. We are going to look at a quick scenario to try and bring to life what these standards actually mean in practice. So what we have here is a scenario involving a parent who's attending a community legal centre seeking legal assistance to pursue custody of her two children, 7 and 10. The parent reports history of domestic and family violence perpetrated by her former partner. The QCLC is not directly representing or interviewing the children themselves. However, the case involves decisions and outcomes that will significantly affect their safety and well-being. The parent identifies as Pacific Islander with strong ties to their Pacifica church community. The parent is concerned about the ex-partner's attempts to use cultural expectations within the community to pressure the parent into shared custody arrangements, despite the history of domestic and family violence. So if you scan that Slido code again, let's, using the Slido code, what are some of the indicators you could look at for this organisation to implement to meet these different standards? I'm going to ask you which standards you think might be relevant to this particular scenario. So we're thinking about standards 2, 4, 5, and 7. So standard 2 is the voice of children. Standard 4 is equity and diversity. Standard 5 is people. And standard 7, knowledge and skill. So if you were thinking about this particular scenario, what are the sorts of considerations that you might have if you were thinking like a child safe entity? And you can just throw out some words or some ideas about what you might think about. So I've got people saying that 2 and 4. Oh, here, I'll share my screen so that you can see the responses. So cultural safety, brilliant. The children's voice. Want to see policies in place that are relating to children. Fantastic. Child's wellbeing is central. Absolutely. Great. I think you've been listening to me. Public commitment to child safety. Fantastic. How can children safely connect with their culture? It may not have to be shared via shared custody with the ex-partner. Good point. So that can form part of the conversation with the client. Children's safety first. Absolutely. Advertisement of child safety in service, children's voice, cultural safety. Absolutely. Making decisions with the voices of children in mind. Yep, absolutely. That's fantastic. So lots of things and ideas. So let's walk through some of these that we thought of. So if we're talking about the voice of children, if we were applying the child safe entities approach, staff would be trained in trauma-informed approaches and would communicate with the parent in a way that models that respect for children's rights to be heard. And the policies might require staff to always consider children's perspectives when providing that advice to their clients. So just prompting questions for the client in terms of what the children would like to see happen. Standard 4 on equity and diversity. And many of you already accurately pointed out the cultural safety is critical. And you might hope to see that the Community Legal Centre has policies which explicitly address and support diversity and equity and inclusion for all children, support and education for staff and volunteers to develop awareness of and sensitivity to diverse cultural needs to support their daily practice, and information materials and resources which provide accessible information and are available in a variety of formats. That's fantastic. I can see some great responses still coming through on the Slido. So somebody said meeting the unique needs of children might need to also consider linguistic diversity. Exactly right. Also, do children so young really know what they want? Well, there might be different ways of getting at that question. You might ask what sorts of things they enjoy doing, who they enjoy spending time with, and you're not interviewing children directly. So obviously you're raising these questions with the client to consider themselves. Standard 5 on people. So for this one, considering that scenario we spoke about, screening and checks of all staff, volunteers and contractors, blue card and police checks and registration to practice law are obviously critical to check. Staff provide evidence of specific training requirements and undertake regular training and debriefing and reflective practice sessions to support managing emotionally complex child-related cases. It's critical to think about the safety and the well-being of our staff. I know many Community Legal Centre staff are flat out just trying to deal with the number of clients coming in the door, but ensuring that you have those processes in place to collaboratively debrief and support one another through some of those really difficult cases. Knowledge and skills. So the CLC requires staff, volunteers and contractors to participate in regular and ongoing training about children's rights and child development, DFV dynamics and their impacts on children, cultural safety and engagement with diverse families, have an acquired awareness in practice and understand mandatory reporting obligations, how to identify red flags and disclosures from parents that may indicate child risk. Another critical thing that you're in an amazing position to be able to explore some of those issues with a client about their children. And the legal advisor may have identified potential risks in the case, like coercive control in that cultural context, and provides advice, around that particular aspect of that client's experience. So there's some of the thoughts that we had about the issues that might, in a scenario like that, you can see how the practice within the organisation itself and the way that the policies and practices and procedures all come together to support that legal advisor when they're dealing with a client that has children in an at-risk situation. Okay, I've got 5 minutes left. It's getting close. I wanted to talk about the sorts of guidance and resources available. We've developed a suite of guidance and resources to support implementation. So it includes information about the Child Safe Standards as a universal principle, practical tools to help organisations assess their readiness, and templates and examples to support compliance. These are really our guiding principles here as we work to bring the new system to life. First, we're starting by engaging with key sector leads. And the goal here is to build strong relationships, really listen and to understand the unique needs and dynamics of each sector. So every sector is different, we know that, and they each have their own way of operating. So what we're trying to do is figure out how best we can support them, you, in other words, particularly through the enablers and the peak bodies, such as CLCQ, who are already working closely with organisations on the ground. Okay, so preparing your organisation to become child safe. Firstly, it's really important that you understand your obligations and the timeframes that apply to you. Naturally, we're not expecting people to be compliant with the 10 child safe standards straight away on day one. We do acknowledge that this is a gradual process and that people need to get ready and have time to develop a plan to tackle the things that they need to have in place. So we're looking for effort towards becoming compliant with the child safe standards. So we're not out there on day one policing whether they're in place or not yet, because we know that this will be a bit of a work in progress. So for you to understand your obligations, to then learn about the 10 child safe standards, to identify your implementation team or a leader to champion the work, assess your level of readiness, and then develop a plan to prioritise the actions that you need to have in place to get there. These are our guidance resources that are available on our website. A self-assessment tool. We have developed this to help you essentially to document the areas that you might need to do some work on to become more compliant. The Bible is the guidelines for implementing child safe standards in Queensland, and this quick reference guide is a summary of the guidelines to make it a bit more palatable and easy to follow. And there's our regulatory approach, which I referred to earlier, which is on our website as well. Oh, geez. Practical tips. So these are some initial practical tips listed in the guidelines on page 14, and they're a great way to get started. They just help you really pinpoint the things you need where you might have gaps. And the purpose of the self-assessment tool is to map your current strengths and work towards building on those, identify the gaps, and then guide your action plan and support documentation for when regulatory monitoring begins, which it hasn't yet. Okay, I'm going to quickly return you to the Slido again. So I'm hoping that you might give yourself another score about how confident you feel about explaining the child safe standards to a colleague, and how confident are you now with applying cultural safety in the child safe standards. And I am going to return you to the Slido to show. Fantastic. I'm really, really pleased to see nobody's fallen below a 3. A couple of 4s still. You need to download some of that material and have a quick look if you can. Still a few people that aren't feeling 100% confident, but that's a huge improvement. It's moved from 5 to 6 as the highest score, and there's a lot more in the 7s and 8s and 9s. That's fantastic. Okay, next question is, using that scale of 1 to 10, how confident do you feel in applying cultural safety to the child safe standards? Amazing. I've got some really quick responses that are telling me things are feeling a bit better. That is, again, fantastic. I'm so pleased to see that. Wow. Thank you. That is absolutely fantastic to see that. And I strongly encourage to build on that quick bit of information that I've laid out there for you all. I strongly encourage you to, are you able to see? Katie, can I get you to nod whether you can see the
We can see
Slido?
the slide at the moment, not the Slido.
Oh, share. There we go. Got that? How good is that? And then the cultural safety is looking better too. Amazing. Thank you so much. Right, I'm going to share it back here. Thank you for answering my questions. Thank you so much for your time today and for your interest in the Child Safe Organisation's work. We know it's a big change. We're committed to walking alongside you and throughout the process. So if you'd like to stay connected or need more information, please do visit our website. Thanks again, and look forward to working together to keep Queensland children safe.
Great. Thank you so much, Anne, and thank you for your time and expertise today. We really, really appreciate it. I'll just say before everyone goes, because I know we're almost at time, that when we close the webinar today, there'll be a pop-up of a feedback survey. Please fill that in if you are able to. Your feedback helps us continually improve our webinar program. And we hope to see you all at the next CLCQ webinar. Thank you and bye for now.
Thanks a lot.